First of all, of course, thank you for inviting me to this conference and giving me the opportunity to have this speech. You know, after several hours when legal philosopher hears about axiology, values, principles, etc., the heartbeat goes up and the blood boils. So let me speak about fundamental things which are absolutely connected with this provocative, of course, with this provocative question. But you know, it is a publicistic one, because there is a serious problem in theory of law, in legal dogmatics, which is connected with European Union, if concrete provisions which states legal principles could be independently the source of legal rules, not standards connect with concrete provisions, but, for example, the Article 2 could be understood as an independent source, the validation source of concrete rules. And this question was quite obvious in literature, in legal doctrine. It is quite easy to find. And that is the true meaning of that question. My speech I would like to divide into three parts. Of course, the subject is very broad, and I shall expand more of the thesis in a written paper. But first, I would like to speak a bit about philosophical context of legal values, because the grounding is absolutely necessary, because I think we need to establish some basic knowledge on the absolutely top level, which is connected with legal philosophy. The second, some remarks about Article 2. Some things have been spoken lately about that, but I think I can add some more. And the three, the clue, the interpretation of Article 2 on the Treaty on European Union, which is done in the case law of CJ, of Court of Justice European Union. So, of course, does law, the question about the existence of legal values is absolutely connected, or it presupposes the question of the law existence at all. It is combined with fundamental matters about the ontology, epistemology of law, and most, or maybe the foremost, so-called in philosophy, cognitive and non-cognitive approach. There is no true knowledge about that. There are several philosophies, as we well know, the several philosophies of law. And this question about legal value and also the presupposition of the existence of law is, as we all know, as old as the history of the mankind, or at least, for example, the legal doctrine. Even in ancient Roman law, there was a reflection, if the law could be understood in a level of existence, or mostly if it should be only, maybe not only, but mostly should be understood in the validation level. And of course, there are some two key points. The borders are only validation, and the fundamental thing, what is the existence. Validation is a conception which is mostly connected with a very strictly way of thinking about positivistic vision of law, especially the which is famous in Hans Kelsen philosophy, that the matter of existence is a no key point of jurisprudence as a science. This is important. The law, the legal values, okay, if they exist, they should be understood in a different approach by different science. It is not matter of legal science, of jurisprudence. It's as the same as the in the Nietzsche philosophy, or maybe Nietzsche doctrine, is an absolutely non-cognitivist approach. There is no morality, no law, no values. These are only linguistic constructs. It's also connected with the very famous approach in language, which is called denominalism. Yeah, these are only names. This is a very odd quarrel about the universalia. Yeah, the universalia. And they think like there is no morality. If you use the term morality, it denotates only, for example, the biochemical standards inside your body, for example. But in a social culture, it denotates only, it's only a matter of, as I have spoken before, a linguistic construct. So it's very strictly and very narrow vision of law and its science. On a very different way, of course, it's a matter of ontology that we claim that in some parts, this universalia exists. And the existence is connected with the independency of some entity. For example, if the terrestrial people would land here, they could understand what the law is. That's the non-absolutely cognitivistic approach, because it's not only our linguistic construct, it's something which exists, and it could be named. Of course, for every lawyer, especially, and every practitioner in lawyer, it's not good for legal practice. That it's also a very it's not so popular standard. Yeah. So we have this in the middle approach that we can agree that in some aspect about the law, the so-called cognitive approach, that the values create standards, like in Ronald Dworkin's philosophy, but they must be concretized by the individual rules. Of course, the tricky question is who is capable of doing that from a normative perspective. If it does we, as the democracy, and if it does the legislator, and in democratic countries, mostly it's okay. Yeah? Because we agreed about this conception, what law, goodness, fairness, etc. is. The problem is if the body hasn't the democratic legitimacy. Yeah? That's the whole point. Because they can speak to you, what do you need to think? What do you need to do? And the second problem is if by that approach, only the concrete rule is given from the very general provision, the matter of interpretation activism absolutely goes up. Article 2 on the Treaty on European Union, it contains a list of values. We don't have the time to speak about the correctness of these values, about its history. It's not the point. It is a certain innovation. In legal doctrine, it is well observed and well described matter that Article 2 is a quite novum in international law, for example, but because it lists in a normative way the catalog of principles. But of course, there are many other provisions, and also a preamble. Preamble is not a provision, where the principles are also mentioned. And as I have said, the key question was, for many times, that if Article 2 gives someone, some legal entity, the competence to provide concrete legal rules only from this provision, only from that, not from any other provisions, especially from the treaty. And the answer to that question lays down in the mostly in legal reasonings, in legal logic. As we know, there are three semantic functions of language. Some divide more, but we can speak about these three, which are the most. First is descriptive one, the description of the word as a semantic function. This is the primary key role of every language. Yeah, we take information between us. We provide the spread of the information about past, about this is what is actually happening, and this what has not come to pass yet, what will be in the future. The second semantic function is the emotive one, but it's completely pointless from the legal perspective. And the third position is the normative semantic function. And of course, for the lawyers, this is the key point. And the first statement, there is a thesis that semantic function of normative is an only semantic function of the legal text. And that is what makes legal text, especially in continental in legal culture, when the sources of law are only made by in the form of legal acts, and that's the only matter of, and this is the only semantic function. The second, the opposition thesis claims that the semantic function could be considered as being descriptive in some way. Generally, it is connected with legal standards. And of course, these two theses are connected with these two approaches. Mostly, the semantic function, the statement that only semantic function of the legal text is only normative, it is in general closely, of course it's closely, to nominalism and legal positivism. The second one is closer to jus naturale conception, especially the conceptual realism, and below that, the jus naturale. And on the previous panel, we were speaking about postmodernism. A bit, of course. It's not a problem without nominalism, because in my point of view, yeah, absolutely, the primary function of legal text is normative one, because without that statement, there is a very tricky definition, the division between jurisprudence and, for example, sociology, psychology, and mostly politology. This is very important matter, and it was well described in especially, but not only, Polish theory and philosophy of law, the so-called problem of autonomy, a methodological autonomy of jurisprudence. It's not a problem, this is not a key matter, the nominalism. The matter is what the interpreter is doing with that. This is the same problem or not as it was with legal positivism, which Gustav Radbruch very well wrote in his last papers. It was not problem strictly with legal philosophy of legal positivism. The problem was what lawyers would do with that, because these are only the ideas. These are tools which lawyers shapes their reality. So, what says the CU? I know the time is going. I had passed a 4 years stop between very good knowing the CJ judgments, and to prepare this statement, this short lecture, and this paper, I needed to get back to the judgments of the Court of Justice of the European Union. Yeah, the book is in open access. It's only in Polish, but today by the AI you can easily, I think, translate it. And there are not a huge number of that judgments about Article 2. And for example, if you know your local judgment, for example, of Supreme Court, Constitutional Tribunal, when you have legal databases, it is quite easy to see the very full argumentation about, for example, legal standard. And the argumentation of CJU judgments is very, very short. This is absolutely obvious, and this is absolutely an unique matter of those case law. I have the time only to speak only about one case, but I think this case, which is very modern because this is very famous for now, judgment of CU about the Hungary TV regulations. This is not a key point for me. The key point is that inside these judgments, I think for the first time, it was written very clearly that the Article 2 provides a mandatory rule. So it's a rule of jus cogens independently. And in previous judgments, as I have spoken, it was a matter of discussion. CJ was, balancing between, for example, Article 2, and there is a matter of, for example, Article 4.2 and Article 0.43 Treaty on EU. But now, CJ treats this as a validation of jus cogens rule. Conclusions. For every theoretics of law, and this is the essence, that the judgment of CJ court is in essence very positivistic. There is a huge lack of argumentation. For example, if you combine, I think not only judges of Polish Supreme Court, Constitutional Tribunal, in general high courts, not only in Poland, but in many other member states, the rulings about the axiology gives you a huge matter of argumentation. Yeah, the flow about legal philosophy, its context, the ideology, etc. The rulings of the CJ are very, very short about that way. They are quite long for a whole, but for example, in this one, it contains a lot of information about past history of the case. But the statement is absolutely not a matter of argumentation, but it's a matter of power. It's an argument of power. I am the High Court of European Union without any argumentation, without any references to legal doctrine, the statement is made. So the lack of argumentation is very obvious. This is connected with the, I think, with the phenomena described in the literature known as majority judicial activism. But it isn't a true judicial activism. It is described in the literature. The CJ came to the legal semantics first establishing the meaning of term, which is primary is in most countries of the member state. Those most countries are connected with in general, the old states from the European Union, and that it came. It's the same as the principle of the many other rules from the treaty. So that's how it works. They do not interpret by themselves or by the philosophy, the legal context. They checked how it is understood by the majority in EU, and that's the answer of the situation of interpretation. In the last words, there is a last anecdote, because, for example, in Poland, there was a huge dispute in general jurisprudence, but not only, in legal doctrine, past 10, 15 years, about the necessity to provide a huge argumentation in legal rulings, the full context of that, philosophical context, etc. It is absolutely in a contrary to the case law for CG justice. Thank you.